Hi, my name is Steve Wald of Stewart, Wald McCulley. We have prepared a little animation video for you to see what Rails to Trails litigation is all about. I hope you enjoy it.
In the mid to late 1800s and through the early 1900s, the railroad industry saw massive growth in America thanks to advancements in technology and an expanding economy. To help spur on this growth and develop critical infrastructure, both the federal government and the states gave railroad companies powers above and beyond those private companies normally enjoyed, including the power to condemn lands necessary to construct the lines. Often, though, to avoid the lengthy and expensive condemnation process, railroads acquired the land straight from the landowners through an agreement. Depending on the language, these agreements gave railroads either the land itself, a fee estate, or merely the right to use the land for railroad purposes, an easement. Both accomplished the same goal from the railroad's perspective, but only one, the easement for railroad purposes, left the landowner with the right to take back their land should the railroad ever abandon its line. The government's action to convert the railroad to a nature trail prevents the land from going back to the landowner, so the landowner is entitled to money that represents the value of the land in the railroad right-of-way. According to the Fifth Amendment of the U.S. Constitution, the government cannot take private land from landowners for public use without paying just compensation. The first part of the lawsuit establishes the government is liable for the taking of the land and must pay money damages. The first, land value, is determined through comparing the taken land to similar land in the area, much like what you would do with valuing any real estate transaction. The second is much more specific to Rails to Trails damages, as it includes things such as the loss of privacy, loss of security, and decreased value of the landowner's property due to the presence of trail. For both parts of damages, both the landowners and the United States bring in experts with competing opinions, and the parties eventually either reach a compromise or present their arguments to the judge, who then decides appropriate compensation. Usually, this is the only process in which landowners may choose to participate, as the expert witness will want to interview each landowner to determine specific issues that could affect damages. Each landowner's damages are determined separately, as each piece of property has its own unique value and considerations.
I hope that answered most of your questions, but if you have any further questions, feel free to contact us at any time via email or telephone call. We'd love to hear from you.